to what I saw on the record, and so I understand what you're saying, but I think in the same thing that Judge Meyer's question was directed towards, like, we have to look at the factual record found by the trial court, and we, other than just her testimony saying like, oh, I don't think he can function, what else would there be in the record to overcome the factual findings by the trial court?
And I think that's incorporated into the IEP. This is something that the school officials prepared. My client was present for the development of it, and it points out virtually all the things, including the problems that he had, the medications that he takes, et cetera. One of our problems in this particular case is that Corey's primary physician for all of these matters on a vacation in Michigan drowned about a month before this hearing. So we were left with virtually nothing. The medical records had no opinions in them that would have supported what this doctor could have said had he been there. And I understand it's not a record, but I think the IEP, which I'd like to focus on, does point that out.
But the IEP, the focus of the IEP should be like what he needs to function in school. And what we're talking about, and there may be some overlap, but what we're talking about is his functioning kind of in the real world beyond school.
I agree. And just, you have to look at this in the context of employment of virtually any kind, because he had ADHD, Tourette's syndrome, where he just have outbursts all the time. He had, in addition, he had post-traumatic stress disorder, and he was taking a number of drugs, all of which are documented in that record: Divalproex for seizure and mood disorders, guanfacine for ADHD, Vivanase for ADHD, and bupropion, which is bupropion XL, which is an antidepressant for depression and mood disorder.
So you're basically saying, in essence, that by virtue of the mental and physical disabilities that Corey has, that he would not be able to be self-sufficient?
Yes, not only self-sufficient, he wouldn't be able to maintain employment, and virtually any kind of employment, because of the fact that he has outbursts.
How long has he been employed at Montgomery Inn?
He isn't anymore.
How
He was
long?
fired.
At the time of our record, how long?
Several months. But all he was doing was, he'd be standing there, they'd say, Corey, take this to table so-and-so with Jennifer or whatever, and he'd go there, he'd take it, he'd drop it off, and then he'd go back to the kitchen. That's all he did. He worked 10 hours a week, and again, that's the only employment he has ever had.
What was the medical evidence with regard to his mental and physical disabilities, other than what they actually are?
The only thing I have is what's in the IEP. I don't have any other. Obviously he was taking these medications, but I guess the most important thing here is that just to stay in school without disrupting the rest of the people, he had to have somebody there to watch him. And when he got out of control, this individual would walk him out of the classroom, and then after he quieted down, bring him back. What I'm saying is, it's not just the medical; it's the behavioral manifestations of these, with or without a medical diagnosis,
That's why I was
that make
asking
it impossible.
That's why I'm asking you, what was the medical evidence other than what the actual mental and physical disabilities are? What was the medical evidence in the record beyond this is what Corey has?
He had 2 major brain traumas, one of which resulted in surgery for the removal of his frontal lobe.
But I'm talking about informational, like you're talking about, the behaviors and all of that and how it's tied. How is that played out in the record?
I think it's explained in the IEP.
I think there was also testimony that when Corey is with mom, that his behaviors are fairly controlled or subsided or something like that, but when he's not with mom, that's really,
And that's probably true to an extent. Since that time, I've had a number of discussions with Ms. Tolbert. I know, I thought she was coming, she is here. That he has become virtually uncontrollable now. We have no doubt that sometime in the near future, he may have to be institutionalized as a result of this.
And Mr. Plotnick, you have about 1 minute if you want to reserve 5.
Let me find my finishing then. I think plaintiff stated it best in her testimony when she agreed that Corey's problem is not his intelligence, which addresses your issue, Judge Zayas, but it's because his behavioral manifestations make it difficult for him to interact with other people and to get things done. He does not have his own bank account, or if he does have his bank account, his mother does all of his banking for him. He doesn't drive, and although he's talked about, and obviously these are outside of the record, but he's made no attempt whatsoever to apply for college, take the SAT, or anything else related to this. It's a sad situation. It resulted from 2 serious injuries as a child, falling out of the window and hitting his head, and another when somebody was playing with a golf club, the head came off and hit him in the head, and he had to have surgery. I believe that we've established that in this particular case, the documentation supports the application of what was the Castle the statute applied to essentially codify the Castle decision. Thank you.
Thank you. Mr. Trollinger, you have 15 minutes.
Thank you very much, and good morning. Chris Trollinger for the appellee. In this particular case before the trial court, the evidence that was presented is exactly as what was found by the magistrate and the trial court. We had testimony by Corey Tolbert. The magistrate in that particular matter had the opportunity to review the demeanor of Mr. Tolbert, talk to Corey. Corey was subject to both cross-examination, direct examination, and questioned by the magistrate in the particular hearing. He answered the questions, and the magistrate was in the best place to observe the demeanor, the competency of the testimony, the coherency of the testimony, and ultimately make the appropriate findings. There was no medical evidence before the trial court at all regarding any disability or other limitations of Corey. The only testimony that was before the court was the self-serving testimony of the plaintiff in this particular matter, who had obviously a financial stake in the outcome. There was no continuance requested, no opinion of a medical expert, no independent medical evaluation that was conducted, and
But
nothing
that's
else.
not required, is it?
It's not required. I mean, there's certainly case law that identifies that when you're trying to prove that a person is disabled or otherwise unable to tend to their financial future, that the medical expert and testimony certainly is something that the trial court can rely upon. But in this particular matter, we had the plaintiff's testimony, who conceded that Corey was able to mow the lawn, do his own hygiene, go to work, navigate the bus system, ride his bike around town, and that really he had no limitations. Cognitive.
What about the aide that was with him? My understanding is around the clock at school. I mean, that's a substantial investment in trying to make sure someone can get through the day each day, and that certainly would suggest difficulty in someone going out, getting a job without assistance.
Sure. So at times during and if you look to the IEP, the testimony or the document suggests Corey did very well. He was both, obviously during this period of time, we had interesting COVID situations where there was remote learning and that sort of thing. Obviously with remote learning, the aide would not be around for that. In the classroom, the aide was certainly there. But even in the IEP, they talked about the behaviors improving over time with maturity and whatnot. So there's certainly evidence within the IEP that suggests that he was turning himself into a leader into the classroom, and other things that identified that while his IEP allowed for when he gets stressed or otherwise have behavioral issues, have an aid available for him, it was not clear in the record that he hadn't otherwise improved, and certainly there was not an aid available to him at his employment when he worked at Cedar Point, when he worked within the trash collection, as also when he worked at Montgomery Inn, that he was independent in the community, unable to maintain his working lifestyle and whatnot.
Is there evidence as to what his income was?
The evidence in the record was that he was making $10 an hour. His hours were 10, he was working 10 hours, but he testified he wanted to work more, but due to obligations at home and that sort of thing.
So
he
how
was
does $10 an hour at 10 hours a week go to being self-sufficient?
It indicates that he's capable of being self-sufficient. It's higher than the minimum wage that is in the community. If you were to impute somebody for child support purposes who was unemployed, you would impute them at least to a minimum wage without any sort of
Well,
independent
it indicates that he's
evaluation.
capable of being employed, but I think if you look into the calculus of his medical conditions and then $10 at 10 hours a day, then how would that go into that he is self-sufficient?
There's
And
no-
Self-sufficiency is the threshold that needs to be addressed.
Sure, there was no evidence to the contrary. There was no evidence indicating that he was limited with his hours as far as his capabilities. He testified that he wanted to work more. He testified he could work more. Mom corroborated that testimony on the record that there was limitations on him on what he was doing, but it was home-based. He was doing chores, studying for his ACT, wanting to attend college, and that ultimately the household income was being limited in order to maximize, his scholarships, and there was some testimony that would indicate that it was kind of done this way in order for the case, as Corey had testified of meeting with counsel and kind of having almost a strategy session prior to trial. So there was no evidence, and it was the appellant's burden at the trial court level to establish that. So the evidence that was before the court, while minds could come to different conclusions, it's an abuse of discretion standard, and the reasoning that the magistrate laid out in his decision and that the court adopted is not an abuse of discretion. It's not unreasonable or arbitrary. There was evidence in the record that was relied upon. It was sufficient, and there was not enough to establish the burden on the other side. So we would ask that, without any additional questions, that the court affirm, as the plaintiff did not satisfy the burden under 311986. Thank you.
Thank you. Mr. Plotnick, you have 5 minutes remaining. And let me ask you to start with the standard of review. We would have to find an abuse of discretion on the part of the trial court, would we not?
No, I agree, and and I quoted that in there. It's the, I'm missing the name all of a sudden. It shows up in every
That's okay. I don't
opinion.
expect you-
I'm trying to think of the name. Yeah, I agree, outraged, but I think it meets its standard, and I'd like to point you to one specific thing that was not addressed in the magistrate's decision that obviously was in the record. It's on page 15 of the IEP. It's accommodations. He needed extended time, double the amount of time than his general education peers. Breaks during testing, 15 minutes per occurrence, 2 times per hour of testing. Says Corey requires redirection when he exhibits frustrated behavior, pulling hair, screaming, banging on desks, to help refocus on his expected work. He also will receive text-speech accommodations except for reading tests. He will also use headphones to tune out external sounds to help him focus and also help aid the text-speech accommodations.
So
I mean,
some
this
of
is-
those might be a reasonable accommodation in employment too, might they not?
They might be, but I've been around a long time, and I don't know of any employers that would tolerate bursts of activity, arguing with people and things like that. I feel very bad about this particular situation. I think we could have done better with the doctor, but we had no doctor because of the fact he was dead. I do think that that record, particularly that particular portion with respect to accommodations, establishes that preponderance of the evidence and the abuse of discretion in not considering all of the items in the IEP. Thank you.
Thank you. Counsel, thank you both very much for your arguments this morning. We will take the case under submission, give you a timely written opinion. That will conclude the arguments this morning for the First District Court of Appeals.
Thank you very much.